Page 13, A 818973, Alfonso Noyola versus the City of Boulder City.
All right, who do we have on behalf of plaintiffs? You may be muted. You'll have to hit *4 to unmute. Or we may have lost you. Is Mr. Barr or someone from his office on the phone? Somebody check in there. So, Ms. Kaler or Mr. Gordon, either one of you there? We're not hearing you.
And Mr. Barr checked in as well.
Okay. We may have lost them. Just now I'm hearing some stray sound. Anybody on the line for Plaintiff Morris or Noyola?
Your Honor, this is Brad Austin, also on behalf of Mr. Morris.
Okay.
I'm calling in separately. I can tell you right now, Mr. Gordon and Mr. Barr are working on just calling in separately, so they should be joining the call momentarily.
Okay. Who's arguing this motion?
It will be Mr. Gordon and Mr. Barr. They're the ones waving on the screen, Your Honor. They should be connected to audio momentarily.
All right. And who do we have for the City of Boulder City?
Your Honor, this is Dennis Kennedy for the City of Boulder City and for Mayor McManus and Councilwoman Tracy Fulda. Also here with me are Josh Gilmore and Andy Champion.
Okay. In Odyssey, it shows no attorney for Kiernan McManus and Tracy Fulda. But Mr. Kennedy, you say you represent them also, as well as the City of Boulder City?
Yes, in their official capacities, Your Honor. They were just named in the amended complaint. They were not named in the original complaint.
Okay. So the minutes should reflect that Mr. Kennedy and Mr. Gilmore and Mr. Champion represent the City of Boulder City, as well as Kiernan McManus and Tracy Fulda in their official capacities as members of the Boulder City City Council. Is that correct, Mr. Kennedy?
That is correct, Your Honor.
All right, Mr. Gordon, are you on the line yet? Well, I have no solution for these technical problems.
Yes. Your Honor, can you hear us now?
Who's speaking?
This is Richard Gordon, Your Honor, on behalf of Mr. Stephen Morris.
Yes, I can hear you.
Great. I apologize for this technical difficulty. We've been on, but now we have a new connection. So I'm here, bar number 9036 for Mr. Morris, and Mr. Barr is also here on behalf of Mr. Noyola.
Okay, very good. All right, let me give you my thoughts after reviewing the briefing in this case. This is a plaintiff's motion for a preliminary injunction. I initially granted a temporary restraining order in this case on August 5th, 2020, the same date as the August 5th, 2020 application was received. This was done because the ex parte application presented compelling arguments of threatened irreparable harm if the special meeting of the Boulder City Council went forward on the following day, August 6, 2020. The circumstances were said to constitute emergency circumstances, and there was no other adequate remedy at law for the plaintiff. Now, having reviewed the pleadings in connection with this preliminary injunction hearing, it appears that the plaintiffs contemplate enjoining the City Council effectively from ever conducting a meeting to consider the issues of potential misconduct and continued employment of the plaintiffs. But such a request for such permanent long-term injunctive relief is simply untenable. It seems to the court that the appropriate resolution here is compliance with timetables that afford proper notice of a City Council meeting to all who may be affected by items on the agenda. In other words, simple compliance with the open meeting law. In their recently filed motion for preliminary injunction, just filed a few days ago on August 31st, 2020, on an order shortening time, plaintiffs contend that they are not suggesting their employment is not subject to scrutiny and possible termination, only that 2 members of the City Council should not be part of that determination or any of the processes leading up to it. These 2 City Council members are Mayor Kiernan McManus and Council Member Tracy Folda. The problem is that these officials were duly elected by the voters. If they are doing an improper job of serving the city of Boulder City, the solution is to turn them out at the next election. For now, the solution to the plaintiff's concerns is for the city to issue proper notice of a public open meeting in accordance with NRS 241.033 sub 1. That's the court's perspective. I won't read aloud 241.033 sub 1 because it's a simple statutory thing, and there's no need for me to read it to the people who are familiar with it. The problem also is that my understanding is that according to the way things are done, there's 5 members of the council, and if somebody is to be terminated or if a finding is to be made regarding their malfeasance or their ethics or their conduct, 3 of the 5 have to vote in favor of that finding in order for it to be a determination made by the council. So immediately, if you disqualify 2 people on the basis that you think they've done something that's unethical, then you've just, as defendants argue, you've just given the plaintiffs a much better contract than they originally had, because that would mean that since 2 members are disqualified from voting, they would still have to get a vote of 3, and that would mean you'd have to get a unanimous vote of all 3, which you might be able to do, but it's not it creates a much better, more bulletproof contract than the plaintiffs originally had. And lastly, if there is a reason for McManus and or Folda to be sanctioned for unethical, improper conduct, and I have no idea whether there's any basis or a lot of basis to the accusations, but the appropriate solution is the Ethics Commission to have them appropriately investigate the matter, decide whether or not these 2 people, or either of them, has been guilty of ethics violations that warrant appropriate action by the Ethics Commission. So that's my perspective on this, which is to deny the motion for preliminary injunction at this time, and with the hope that the parties will move forward following the suggestions made by the court. So since this ruling is basically adverse to the plaintiffs, I'm happy to hear from whoever the chosen spokesperson is for plaintiffs Morris and Noyola.
Thank you, Your Honor. This is Richard Gordon on behalf of plaintiff Stephen Morris. And the one thing I want to mention, Your Honor, is that pending before the court today are really 2 separate motions for preliminary injunction. The original motion for preliminary injunction deals exclusively with the original open meeting law violation that the court enjoined. And then, as the court noted, a subsequent motion was filed after the amended complaint was filed. And the court has addressed, I think, the first motion when it is asking the parties to simply comply with the open meeting law, specifically 241.0331. And we don't disagree with that, Your Honor. The only thing, and where I think some clarification may be needed as to this first motion, is that as we've argued in the original motion, what the open meeting law requires is that a public body give written notice to the persons that are affected, in this case, the plaintiffs. And that is what did not occur when the original meeting was scheduled. The public body did not take action to authorize notice. And so that's the first motion. What we proposed,
Mr. Gordon,
yeah.
That's a moot point. That date has come and gone. Injunctive relief was granted, affording you protection from a meeting taking place on August 6th. That's water over the bridge, under the bridge.
Well, we're here today on a preliminary injunction to enjoin what you previously enjoined because it's void. You know, under the open meeting law, and that was the basis of the original complaint. If there's a violation of the open meeting law, that act of the council is void. And so when Tracy Folden, the facts of this case, prepared notices to give unilaterally to the plaintiffs, and when Mayor McManus authorized service of those notices, those were not the acts of a public body,
Mr.
which
Gordon,
is required.
Mr. Gordon, you're beating a dead horse. That's behind us now. We have to look forward as to what will happen going forward from today.
Sure.
And I'm not going to remove or enjoin McManus and Folda from being able to participate for the reasons I expressed. I just think that is an unbelievable overreach and a failure to recognize the separation of powers. So I'm not going to do that either.
That's right. Yes. Understood, Your Honor. We just, as the court indicated, the notice requirements need to be complied with. There's a dispute as to what the notice requirement is. And that's, I suppose, because we may be back here if the same attempts to notice without a public body meeting occurs.
And if you are, I will be
authorized
here.
By the public.
Very good. Okay. Mr. Kennedy?
Thank you, Your Honor. Your preliminary ruling is correct in all respects. What the order should do is it should deny the first motion for preliminary injunction and deny the second motion for preliminary injunction. As simple as that.
Yeah, I do think they both need to be acknowledged because they were, in fact, two separate things, and the relief sought was different in each one. So, yes. Mr. Kennedy, I'm going to ask you to, well, I'm not going to have an order prepared on this. It became a moot point. The defendant had an ex parte application for an order shortening time to get the hearing heard as soon as possible, which we did. I believe I signed that OST in the TPO system, and I believe it's filed. But I need Mr. Kennedy to prepare an order addressing both motions for preliminary injunction by date filed and indicating that they're denied.
Your Honor?
All right, Mr. Kennedy, do you have any questions as to what is in the order?
No, I don't know what all that noise is, but we'll prepare the orders, Your Honor.
Okay, all right, thank you.
Yes, thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor.